Good evening. You're with us live. This is Thursday, August 20th, and tonight's town hall will be about age discrimination in the workplace. I'm Liz Kruger, state senator from the east side of Manhattan, but I zigzag around Midtown and the Flatiron district, so just say Manhattan. We're glad you can be with us here tonight. We want to remind everybody that this is being viewed live on Facebook, but there are also people who call in and listen by phone, and we welcome everyone. But please, if you're on the phone, keep yourself on mute. This isn't an interactive town hall. This is my guests and I talk, you listen. At the end, we'll have a Q&A section. Some people sent in their questions in advance. Some people will type them into Facebook. We've been doing this now for quite a few weeks, and I think you'll find you gain really valuable information in a short period of time. We're, of course, glad you're all feeling well enough to be with us tonight. I want to just remind you of a couple of fairly critical things for us to be doing. One, the census. I'm a broken record, but I'm saying it again. If you have not filled out your census form, either the one that got mailed to you or online, or somebody knocked on your door and said they came from the census and they want to fill it out, please, 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 we need every New York City resident to fill out their census forms. You can go to 2020census.gov, or you can call 844-330-2020. Again, 2020census.gov or 844-330-2020. You might also be running into people who are census takers coming into your building, standing on your street corners, bumping into you in the supermarket. Please be nice, cooperative, helpful to the census takers. These are good people willing to get out there and help us get the count. We've been getting some reports that some buildings are not allowing the census takers in. Please, there's nothing scary about them. They're not threatening. They just want basic information so that New York City can get its fair share of federal money for the next 10 years, and we can get our fair share of congressional representatives deciding the laws for the next 10 years. Under the law, census workers must be allowed into buildings. In fact, a management that prevents them from entering can be actually financially fined. So remind your manager, remind your doorman if perhaps they didn't get the right information. We're going to let those census workers come in. We're going to make sure every resident is counted. And it's particularly important in my district because, let's face it, most of us out there live in buildings with doormen. You don't get into those buildings unless they let you in, and I respect that they are doing their jobs, but we really, really need the census numbers to go up. Next topic, since everyone's talking about politics and voting, and we've got the DNC convention finishing up tonight and the next one coming up soon, you have to plan now for how you will cast your vote in the general election, regardless of what party or who your candidate is. We learned from June that there were a bunch of problems with elections during a pandemic. So the state has been expanding our rights, and hopefully we will see less of a problem in November than we saw in June. I have been very outspoken about the problems we saw and the fact that people didn't get their absentee ballots in time to return them in time to have their vote counted. We're going to do everything possible to make sure we do not see a continuation of that for the November election. The legislature recently passed, and as of today, the governor signed 3 bills that are critical for making the November election work better. 1, all voters can now request an absentee ballot if they are concerned about COVID and don't want to walk into a polling site on election day. 2, the Board of Elections must count all the ballots postmarked on or before election day and received within 7 days after the election. The board must also consider all ballots without a postmark to have been received by November 4th, the day after election. They're going to be mailing out those absentee ballots earlier than they did for the primary, and we are giving you more time to get them back in. I personally still think the best option, if it's realistic for you, is to vote early. That's a change we made a year ago, where we've opened a certain number of sites in every borough where you can go and fill out a ballot there and file the ballot there 10 days in advance of the election and all the days in between. This way, you know you're going to a site that's not going to be overcrowded because there really is not crowds at the early voting sites. You can pick your own time, pick your own day that works for you, and you can assure that you're filling out a ballot that is getting right there into the machine with your watching it the day you go to vote. So I'm urging people to think about the early voting as an option if they're prepared and able to get outside anytime 10 days up to the day of election, to make sure that they are requesting the absentee ballots from the city of New York. They're going to be mailed out on around September 18th and 19th. And you can go online and file for an absentee ballot that way. You can also call the New York City Board of Election, 1-866-VOTE-NYC, 1-866-868-3692. You can call my office. We will help you make sure that you understand where you can vote if you want to go to a site, or how to get an absentee ballot sent to you through the process that way. Let's see. The Board of Election can tell you where early voting sites are located, but probably not until September. I know that we were talking to them today. They're still looking for additional sites. But again, what we really want to emphasize is it's every New Yorker's right to vote if they're eligible to vote. We've had a pretty low turnout. Most people think wherever they are on the political spectrum that this is a pretty damn important presidential election this November. So we want to do everything we can to help people to make sure they vote and that their vote is going to count. All right, getting to this evening's event. The New York City Commission on Human Rights recently issued guidance on age discrimination in the workplace and age-related COVID policies. Tonight, we are going to hear from the authors of that guidance. I am very pleased that they are both able to be with us. Our first presenter is Dana Sussman. She's the Deputy Commissioner for Policy and Intergovernmental Affairs at the Commission on Human Rights. I want to thank Dana for spearheading this guidance effort and making New York City a leader in this space. Dana is going to talk about an overview of the work of the Commission, give information on the legal framework for the guidance, and the need for age-related discrimination protections. Then we're going to hear from Bianca Victoria Scott, Policy Counsel at the same Commission, who will talk about the major takeaways and best practices to support a multi-generational workforce as it relates to hiring, managing employees, and retirement. Again, afterwards, we will have a Q&A where we'll have an opportunity to ask both of our guests some questions. And again, if you're on Facebook and you think of a question you'd like to ask, please feel free to type it in. My staff will be typing it then into me on the computer. We will try to get to as many questions as possible. Now, I've been doing a series of these town halls, and sometimes I don't know the presenters, but I will tell you that I have worked with Dana Sussman on several crucial issues for all of us, and she is exactly the kind of person you hope to find in government agencies doing this kind of work, because she is smart, thoughtful, comes up with good answers, and is an honest straight shooter. So with that, I will hand it over to Dana Sussman.
Thank you so much, Senator Krueger. It's a pleasure and an honor to be with you tonight, along with my colleague Bianca. It is really a testament to several of the events that Senator Krueger and her staff, particularly Wendy Brennan, have put on over the past couple of years on age discrimination that got many of us at the Commission thinking about what we could do at our office to elevate this issue into the public discourse in ways that I think many of us and many of you may feel is not getting the attention that it deserves. And it really was some foundational work that Senator Krueger has done on these convenings that has brought us really to publish the guidance and to be here with you. So I'm going to share my screen and bring up our presentation for you all to see. Before we jump into the guidance itself, I wanted to give a brief background about who we are and what we do. So we are the New York City Commission on Human Rights. We are the city agency that's charged with enforcing the local anti-discrimination and anti-harassment law in New York City. That's called the New York City Human Rights Law, which covers your rights in the workplace, in housing, and in public accommodations. And we have a team of lawyers who accept complaints from the public, who investigate those cases, prosecute those cases through an administrative trial, and are able to obtain damages for the individual who experienced the harm or the discrimination, changes to policy. We can issue penalties or fines and a whole host of other changes that might be required at that employer or at that housing provider. In addition, we have an office that educates the public about their rights and responsibilities under the city human rights law. And Bianca and I work within the policy team, issuing different policy positions, working on legislation, and a whole host of other things. So just to put a finer point on it, the city human rights law prohibits discrimination in 5 key areas. The most common ones that we see at our office start with employment. Housing is the next most common, and then after that is public accommodations, which are all public spaces that are open to the public, grocery stores, restaurants, libraries, parks, anything that offers goods and services to the public. And then we have 2 other areas of protection that are represent a smaller proportion of our work, but are quite important and unique in New York City. Discriminatory harassment, which is like a civil version of a hate crime, and bias-based profiling by law enforcement, which is our specific oversight over the NYPD when there is a discriminatory motive behind a police action like an arrest or a stop. In most cases, you can file with us or you can call us to start a case within 1 year of the last discriminatory act. That's not a lot of time, which, for folks who are navigating different bureaucracies or trying to figure out if their rights were violated and what to do, you have 1 year to file with us, or to initiate, a matter with us. The exception to that, and that's a recent change in our law, is that if it's gender-based harassment or sexual harassment, New Yorkers now have 3 years to file at our office, which is consistent with the timeline to go to state court. What's important to note is that the city human rights law allows you to come to our agency with or without an attorney. We were set up in a way that makes us friendly to folks without attorneys, but people can come to us with attorneys as well. Or you have the option of going into state or, in some circumstances, federal court using the rights you have under the city human rights law. And you can do that up to 3 years after the last discriminatory act. So 1 year to come to our agency in most situations, 3 years to file in state court. So we are, and I should really start with this, we have one of the broadest and most protective anti-discrimination laws in the country. And if you look at all of these protected categories, all of the areas in which you are protected from discrimination, you can see how clear that is compared to federal law, which protects workers, in about 5 or 6 categories: race, religion, age, disability, national origin, and sex. I believe I got them all. Under the city human rights law, you have many more protections, many of which are unique to the city human rights law and are not as common across the country. A few key ones here. Obviously, we'll be talking about age today, but there's pregnancy and lactation. There's explicit protections there. There are prohibitions against asking now about salary history in recruiting and job applications and hiring, which is an attempt to narrow the pay gap for women and for people of color. We've had protections for gender identity in our law for almost 20 years now. That was just sort of codified in a way by the Supreme Court in June. And we've had sexual orientation protections in our law since the mid-'80s. And you'll see many others there. And there's lots of materials on our website about all of these protected categories. So tonight we're talking about age discrimination and our legal enforcement guidance. We published this in July, I believe. Time is often difficult to measure at this point, in July, because we felt like people were not aware of the broad protections against age discrimination that exist within the city human rights law. And we've issued legal enforcement guidance on different areas of protection over the past 5.5 years where we felt it was either a new protection or it was a protection in the law that was underutilized or misunderstood. And so this, I believe, is our 8th or 9th guidance document, not because age discrimination is a new phenomenon or it's a new protection, but because the federal law that protects against age discrimination, the Age Discrimination Employment Act, or the ADEA, is not as strong as one would like. And in fact, kind of creates protections around age in sort of this second tier status. It doesn't have the same strength as the protections for race or for sex or for other areas of protection, but has been weakened by federal court case law. And we felt it was very important for us to talk about our protections as separate and distinct from the ADEA. We also use legal enforcement guidance to use it as a way to talk about these issues. It's not just about talking about your rights under the law or your responsibilities under the law, which is very important, and we want to be very transparent about that, which is why we put out this guidance. But another purpose is to create conversation around these issues, to shine a light on these issues when we think that they, in many circumstances, are so pervasive that we don't even challenge them, and that really to kind of challenge those assumptions, to start those conversations with employers, with people who feel like their rights may have been violated, about addressing these things and calling them out. So our purpose is sort of multifaceted. And, we highlight some of the things in the guidance, and Bianca's going to talk about all the different areas of protection, or sort of areas that we discuss in the hiring process and the hiring and the employment relationship. But some of the things that we hear, which are pretty kind of par for the course, are postings that say seeking recent college graduates only, or perfect job for a recent college graduate. That assumes, that puts in a whole different, kind of assumption around what kind of person they want to hire. Will they seriously consider someone who's older? What assumptions are they making about those recent college graduates versus older applicants? It really chills, I imagine, the ability for older applicants to even apply if that's what they're seeing. They're not going to believe that they're being taken seriously for that position. Or, workers from Gen Z are so entitled. So we also, and we'll go into this in more detail, I think on the next slide, the city human rights law protects all workers based on age, both younger workers and older workers. And that's another conversation we want to have, because we know that there are assumptions being made about younger workers. It may not be as harmful as the assumptions that we see with respect and the treatment that we see around older workers, but they exist. And so we also wanted to include that in the conversation. You're getting old, aren't you ready to pack it in? Talking about, pressuring people to accept to retire or to be sort of targeted for layoffs because of their age. Our clients prefer someone who's older, more experienced, or, a posting that might say you must bring youthful energy to the job. So just a few of the examples, and we'll talk about some of these as we go along. So as I've mentioned already, the New York City Human Rights Law, it has no age limit. Obviously, we have to take into account some federal laws and state laws around, you can't work until you're a certain age. All of that preempts us, so that is all incorporated. But under the City Human Rights Law, protections exist all across the age spectrum. And in many ways, the City Human Rights Law is more protective than the Federal Age Discrimination Employment Act. And I think one key area in which we are more protective is around what's called mixed motive cases. So under the City Human Rights Law, if age is one of several factors in a discriminatory decision, there is still a right to bring a case. There is still legal protections available. The way that courts have treated age discrimination under federal law basically says age must be the only factor in the discriminatory decision or in the decision. But we look at this as part of, there could be other factors at play, but if age was one of them, a case could be brought to the agency and we can look into that. And that also recognizes intersectional claims. So it could be age and gender. It could be that an older woman is treated differently in the workplace than an older man. So we're not just looking at age across the board, but we can actually look at sort of subpopulations within that and look at how, how age discrimination impacts an older woman. It could be partly animus based on gender and partly animus based on age. And that's, that would be a claim under our law that would survive where it may not, or there might be other complicating factors under federal law. And so we highlight in the guidance that age discrimination impacts older and younger workers. And we highlight some recent statistics because while we have been working on this guidance for a very long period of time, over a year, we publish it in the COVID pandemic. And so we wanted to recognize the current economic crisis that we're facing and how on both ends of the age spectrum, workers are really at great risk. So we know that unemployment rates, and the data is probably even more dramatic now than it was in April, but unemployment rates, quadrupled once the pandemic hit and really went national in April. And then data from June says that 48% of younger workers between the ages of 16 and 24 were employed in heavily impacted industries, and much of that is like the service industries that were shut down, and some continue to be. And we will also talk about our COVID-19 supplement to this guidance, because again, the age guidance is intended to speak to this moment and beyond this moment, hopefully. And the COVID-19 supplement that we published speaks specifically to age discrimination and COVID-19 specific factors. So the main ways that discrimination can manifest in employment are three. There's disparate treatment, which is I'm treated differently because of my age. And that can be in the hiring process. It could be in treatment while you're working, in promotional opportunities, in assignments, in harassment. Harassment is a form of disparate treatment, being harassed or mistreated while you're working because of your age. Disparate impact is when there is a neutral policy that disproportionately impacts one protected group. Now, those are really hard cases because employers can say, I have a legitimate reason for this. And if they can show that it was a legitimate reason for that neutral policy that harmed only one group, then they will prevail. So those are harder cases, but we do have protections there. And in some cases, employers can't come up with a legitimate reason that will convince the judge or the agency. And then there's retaliation. So if you raise concerns about discrimination to HR, to our agency, to your supervisor, and you're retaliated against for that, if your shifts change, if you're demoted, if you're fired, if you're just start to experience harassment, that is also a violation of the city human rights law. And as we started to develop this guidance, we started to recognize that stereotypes and assumptions about older workers are at the root of almost all of this. About ability, about cognition, about so many things that are rooted in just misunderstood or harmful stereotypes about getting older. And so we'll highlight how that plays out in different areas. And then our remedies, as I mentioned at the beginning, we are able to get, for those who've experienced discrimination, damages. So that's associated with, if it's emotional distress or other forms of harm that you've experienced. So that would be money damages for that. There's also, if you were terminated, there could be back pay, there could be front pay for how long it might take for you to find another job. And then for broader change at the employer, policy changes, we might require training. And then we also often require monitoring, meaning that our agency, our law enforcement bureau, will continue to monitor that employer to ensure that those changes are happening. So whether it's hiring practices have changed or internal reporting practices have changed, we can still kind of stay in it, even if your case is resolved, to make sure that they're keeping up their end of the bargain. And with that, I'm going to turn it over to Bianca to talk about some of the specifics in the guidance, and it follows along sort of the employment relationship. So from job posting and recruitment all the way to retirement and layoffs. So I will continue to toggle along, but I will mute myself for now.
Thank you so much, Dana, and welcome, Bianca. I didn't mean to not rave about you before, but I haven't actually met you until up to tonight. So now, take it away.
I can rave about her.
Okay. Good. Consider yourself raved about.
Okay, great. So Bianca Victoria Scott was the key drafter of this guidance, and so I felt it was really important to have her kind of speak to some of the details, some of the key information in the guidance, because she has been working on this for a year, or if not more, and she's been instrumental in getting us across the finish line on the guidance. So and a partner in all of the work at the agency. So I will kick it over to you, Bianca.
Great, thank you both so much. Senator Krueger, thank you again for having us. Very glad to be here. Dana, great intro. Yeah, just to highlight again that while we were working on this guidance, we were really realizing that so much of this is based on stereotypes and things that are so embedded in our culture that we don't even realize it. So it's really important to have a document like this and to be aware. As already mentioned, I'm going to be talking about the main takeaways of the guidance, and I just wanted to highlight too that we're going to have examples that are straight from the guidance posted on each slide, and I'm not going to read them out, but I just wanted to encourage you to look at them and also to get a sense of the kind of examples that we have. And each of these slides represents a different section of, as Dana mentioned, the different stages of the employment-employer relationship. And so there are multiple examples for each one in the actual guidance document. So first we have job postings and recruiting. Age limitations are not permitted unless they're explicitly required by federal, state, or local law. So for example, as mentioned, like child labor laws, or needing to be 18 years or older to serve alcohol, and also hiring of certain civil servants like police officers or fire persons. Job postings should convey the required qualifications of the position without stating implicitly or explicitly the age group of the desired candidates. So generally employers should avoid using terms that are affiliated with certain age groups and should instead frame job qualifications in an age-neutral way. So for instance, for a technology-related position, a job posting could list specific skills such as familiarity with a particular software program that's necessary for the job. So as Dana touched upon before, using the term like recent college graduates, generally those are going to be people who are in their early 20s, and so older adults will likely see this and say, they're not looking for me. Or phrases like youthful energy, digital natives can also be clearly targeted towards a younger crowd. Next section, we discuss hiring, which arguably is when age discrimination is the most pervasive, whether it's implicit or explicit. And although it's not a facial violation of the law, or in other words, it does not violate the city human rights law on its own, a discriminatory motive can be inferred, or we could see that there's a discriminatory motive when an employer unnecessarily asks an applicant about age. So we'd also discourage requiring birth dates at the application stage if the job doesn't have a legally required age limitation. So again, even though it's not an automatic violation of the law, it doesn't look good if or if an employer asks, how old are you? And there's just absolutely no relevance to the position. And again, as mentioned before, age cannot be any part of the employer's motivation for denying a person employment. It doesn't matter if it was a minor factor or the main factor, it can't be any factor. Another thing that is pretty common, I think you'd agree, is the idea that people can be overqualified for a position. Often that term is proxy for someone who is older or too old for a position. And generally what we'd suggest is if an employer is actually concerned that an applicant with more work experience might be bored by the position or dissatisfied with the pay, The best approach is to be clear about the responsibilities and expectations for the job, as well as the level of pay that's available, and let the candidates decide for themselves whether they're still interested, rather than the employer just rejecting people outright who have more experience than they're looking for. Again, neutral hiring policies that have a discriminatory impact are also impermissible under the New York City human rights law. And I just wanted to highlight too that in some jurisdictions, whether applicants can bring an age discrimination claim under federal law is questionable. Some say no, some say yes. But here under the city human rights law, applicants can always bring a claim, whether it's age or some other different protected category. In the next section, we talk about while you're on the job, while you're employed at the employer. So our standard, again, is you cannot be treated less well based on your age, in this case, or any other protected category. That's what discriminatory treatment is. And so different lesser treatment includes things like being subjected to lesser terms or conditions of employment like pay, or denials of work opportunities, demotions, and harassment. Harassment covers a broad range of conduct, and it occurs when an employee is subjected to behavior or an environment that is, the terms we use specifically are demeaning, humiliating, or offensive because of their age. And an employer's single comment may be enough to constitute harassment. This is in great contrast with federal law that requires severe requires the conduct or behavior to be severe or pervasive. So generally across the board, the New York City human rights law is going to be much broader than federal law. What it's considered to be in our official standard is that federal and state law have to be a floor below which the city human rights law cannot fall, meaning that we always have to be broader and remedial. And just wanted to highlight that. Also sorry, Dana, could you go back a second? I just wanted to highlight in this example, what Dana touched upon earlier too, was that someone could come to the commission and bring a claim of both, gender and age discrimination. So here, a younger woman is being treated differently and less well, not taken seriously, dismissed, as compared to an older man in this case. Thank you. The next section, we discuss layoffs and termination. Layoffs cannot be used as an excuse for age discrimination, and employers cannot terminate based on age, of course. And as Dana mentioned earlier too, while corporate or organizational restructuring or downsizing because of finances, like budgetary concerns or eliminating a job position, are often legitimate business decisions, they can't be used as pretext or an excuse for unlawful age discrimination. So what this means is that if a lot of employers are going through tough financial times right now, and if they need to make some layoff decisions, they can't just look at their employees and say, okay, everyone who's over 50 or who's younger than 30 is going to get cut. That's just, again, age cannot be any part of the decision. Also, older workers are often at higher risk for layoffs. And although kind of similar to the asking someone what their age is when it's not relevant to the job position, though replacing an older worker with a younger worker is not on its own a violation of the city human rights law, it could support a claim of age discrimination against the terminated employee by the employer. Next section, we discuss retirement. Employers violate the New York City human rights law when they force an employee to retire at a specific age, unless there is a legally mandated retirement age, as is required by some state laws. Example, again, is policemen and other certain civil servants. Forced retirement ages usually are premised on discriminatory stereotypes about older workers' ability, whether physical or cognitive, as Dana mentioned earlier, or their desire to continue working. So again, assuming once someone hits a certain age, they should retire because they can't or shouldn't do the job anymore. Taking a worker's age into account also when considering whether to renew their employment contract is also impermissible under the New York City human rights law. So again, cannot have age as any part of an employer's decision. certain types of retirement programs are legal. So federal law permits early retirement incentive programs consistent with the Age Discrimination Elimination Act. So this means that programs which are voluntarily offered and are meant to benefit older workers are permitted. And so you may ask, well, if the city human rights law is supposed to protect everyone regardless of age, doesn't that treat younger workers less well? And the answer is, well, in the city human rights law, we have an explicit carve out for retirement programs that abide by federal or state law. So it's written into the law itself that these specific programs that follow federal and state law are permitted. Next, we have retaliation, which is we have pretty broad retaliation standard, and this can occur not just for age, but for any of the protected categories. Retaliation is when an employer takes a negative action or punishes an employee for engaging in what we call a protected activity. And we define what protected activity is in our law, and it can include opposing a discriminatory practice that is prohibited under our law. It can be raising an internal complaint. So if you go to HR to complain about something that's also protected under our law, so age discrimination by your employer, gender discrimination, race, anything like that. So if you complain to HR and your boss finds out and then takes some kind of negative action against you, that is retaliation. Also filing a complaint with the commission or in any other enforcement agency or court. And lastly, testifying or otherwise participating in an investigation or proceeding that's related to an unlawful practice under the city human rights law. So if your coworker, for example, filed something because they were discriminated against and you are involved as a witness or something like that, and the employer takes a negative action against you because you're involved, that would be considered retaliation as well and covered. And also the negative action could be as severe as demotion or removal of job responsibilities or being fired, but it could also be less severe, like relocating an employee to a less desirable part of the office or shifting someone's schedule so it's less convenient or reducing their involvement in group projects. So it covers the whole spectrum. So best practices, these are just a few of the ones we have listed in the guidance, but I wanted to highlight something that I think employers will often overlook, which is making sure that externally and internally facing materials, including recruitment materials, represent a range of age diversity. I think it's just something that's generally overlooked, especially in certain spaces that maybe, let's go with technology because that's a pretty common assumption one, but like tech companies looking for people who are on the younger side, or maybe their recruitment materials, everyone is in their 30s or 20s, something like that. So being aware of that. And also one that's not listed here, I believe, is making sure that any kind of anti-discrimination training or bias training, that age is covered in that as well. That can also be overlooked. And lastly, as Dana said, we been working on this for a long time. We had planned on releasing this guidance earlier this year, and then COVID-19 happened. And then as some time went on and talking to a lot of constituents, we realized we need to have something that is specific to COVID-19 to supplement whatever guidance we put out. So it's a relatively more brief document that we will update as needed, because as we know, things are constantly changing in this climate. But we wanted to ensure that everyone knew, that employers knew, employees knew that protections still stand during COVID-19. Something that has come up is that employers cannot adopt policies that treat workers less well based on age, even ones that are intended to be kind or benevolent. So for example, employers saying, okay, all employees who are over 60, you have to work remotely. You can't come in because we care about you. Well, that seems nice. It's not legal. Like you're banning your employees from the office. And really the better thing to do would be to have everyone who would be able to satisfy their job requirements remotely to give them that option, right? Or to just force everyone to work remotely if that's possible. Yeah.
Thank you so much. This was great. And I'm seeing the last slide gives the contact information. I don't know if I jumped in too fast here, sorry. But
No, that's
okay.
great. You can
All
you can
right.
do it for us. I will just add on for the contact information. So for folks who want to just learn more, our website's a great resource, nyc.gov/human-rights. We can also make sure that we send out links to the age guidance, directly through anyone who RSVP'd. I think if you go to our homepage and just toggle through the slides on the homepage, you'll see it. It might be the second or third slide. And this 212 number is the number to call if you, and that for the folks on the phone, it's 212-416-0197, 212-416-0197, and that's the number to call to reach our info line, which is staffed during normal business hours. And typically you'll get a call back. So you'll leave a message, you'll get a call back within 24 to 48 business hours, 1 to 2 business days. And that will be the first step in exploring your options as to whether you could file a complaint with our agency. You can also fill out a form on our website, which essentially does the same thing. Filling out the form on our website is not filing a complaint, but it's connecting to us, and then someone will respond to you either by email or by phone, whatever is your preference, to start the process. You can also, if you forget the number, you could always call 311 and just say Commission on Human Rights. Our policy email address is here too. It's policy@cchr.nyc.gov, and that is to reach us. We are the policy team. There's 2 or 3 more people, but these are the people that look at the policy email and can respond broadly to questions, can direct you to resources. We can't provide legal advice because we are not your lawyers, but we can answer sort of general questions or talk to you about the process and help guide you to the right people if we are not the right people. So I'll pause there because I know we probably have some questions.
Thanks. We have a lot of questions, so I'm going to try to keep them moving fast and hope for shorter answers. But one of them is exactly the last or a variation on the last example that was just given. So let's say you are a older worker and you have been advised to be concerned about COVID because you're at higher risk given your age and perhaps other medical issues. And now you have an employer who says he wants you to come back to work. And yet you think that puts you at greater risk. Are you protected in some way because you are older? Or what should that person do?
So an employer can offer to have workers work remotely. And if an employer offers that to their staff, even if they, if they're doing it based on age or pre-existing condition, they, as Bianca said, basing it solely on age is not, is a violation of the city human rights law. But, we are not, to be totally transparent, auditing every employer in New York City all of the time. If what we are advising employers is to look at our disability accommodations framework. So age under the city human rights law is a protection against differential treatment and harassment, and as we discussed, some of those neutral policies that can have a disproportionate impact. It does not provide a right to an accommodation by itself. However, what we know about COVID, and again, this is changing rapidly, is that many very common conditions are put you in a vulnerable category. And all of those conditions would be a disability under the city human rights law. The city human rights law's disability protections are quite broad. And so looking at accommodations in that framework is the best way to go as far as trying to accommodate the health concerns of employees.
Great. So some of the examples also included, highlighting that they're really looking for new college graduates or they're trying to get at your age. Some people apply for jobs through an online system. A lot of places make you file an application online, and that questionnaire asks you what year you graduated college. So it's not asking your age or if you're a recent college graduate, but it's clearly making you give a piece of information that will tell them that. And the questioner's point is they don't let you finish the questionnaire and press send unless you fill out the year. I'm assuming you're not advising lying on the questionnaire about the year you graduated college, but are they allowed to do that?
Bianca, do you want to take that one?
We can both do it. So, I mean, this is something that we've talked about internally a lot because it's such a, like, I feel like many of the practices, especially surrounding graduation dates specifically, is so common and it's been done for years, and it's kind of a hard thing to suddenly, I guess, say like that's not permitted. There could be other reasons that so I'm just talking through kind of the issues that we've seen with it. Like there could be other reasons why employers would need that information to, just make sure that this person went to the school that they went to, that they said that they went to, or got the degree that they had, just clarifying the education that they received. But I think ideally, and best practice, if possible, would be to not require that college graduation year to avoid any kind of like implicit or explicit bias that may occur on the employer's half, right? Because they could see, oh, they graduated college 30 years ago, and not realize even consciously that they are taking that into account when they're considering this person as, a possible employee.
Exactly. My grandmother went to college from age 90 to 97. She would have shocked the hell out of them at the interview.
Wow.
So
I love that.
You just never know, do you? So when you're trying to prepare a client how should my clients prepare to seek legal advice if they suspect discrimination? Was the actual question. What kind of evidence should they be trying to collect? What
Right.
kind of verification? What is helpful to them trying to prove their case?
Sure. So because so much of this happens, we understand at the hiring stage, the hiring cases, and I was an employment attorney before I joined government, hiring cases are the most difficult to prove because you're operating in a silo. You have no clear, you don't have comparators. You don't know how other people are being treated. You don't know who else is applying for the job. You're operating in a complete bubble. And so I think the best thing to do if we're talking about hiring is in some circumstances, we want to hear what you're experiencing. So you can come to our agency and just share information, and we have the ability to initiate our own investigations on behalf of the city of New York. And we can request information. How many people have you hired in the past year? If you have their age or other information, we want to see it. What kind of questions are you asking? What kind of training has your staff done to kind of see the broader pattern? We recognize it's going to be very difficult for people to give us all of that information and at the outset. But if you suspect that there is something happening, you're qualified, you got in the door, and then things started to go a little left of center, that's information that we want to know, and we can do that. We can try and gather that information from the employer with with a case from you or on our own as a commission-initiated case. Otherwise, I would say document. So if it's a contemporaneous, email to yourself, what happened, when, with who was there. You can take pictures of things on phones. You can, that's really going to be very, very useful. If something happened, tell someone else so that they also have a recollection of it in real time. And so that you can pull from their memory as well. So that's sort of the quick response.
So let's see, jump to the next question. So if you apply for a job from a private sector employer and you feel you're going to get the job because you're old, is there any role here for the EEOC, and can they be valuable in helping you deal with this? Explain a little bit about the difference between EEOC and your agency.
Yes, sure. So the EEOC is our federal counterpart, and they enforce the federal age discrimination laws. As we've noted, the federal laws have fewer protections than the local laws. And so it is something that you can take your experience and go to the EEOC, or you can come to our office. You can't have cases at both. You've got to kind of pick your agency. But you can go to the EEOC, and we have great partners in the federal EEOC offices in New York City. But we do encourage folks to consider coming to our office, because the underlying law that we enforce is a lot more is stronger than the federal laws.
I just wanted to also mention, I don't think we mentioned it, that at the very end of our age discrimination guidance, there's a table that compares federal and state and city law in different categories. So that could be helpful to anyone if they wanted to get a clear idea of specific differences in the laws.
Thank you. So people are asking, many recruiters and HR people seem to be finding loopholes, get prior salary information since the law was passed to protect job seekers from disclosing this information. Do you know of anything that anyone's trying to do about that? They specifically were asking about the Attorney General playing a role here. Is there a role for the state AG or the city in catching people violating these laws?
So we would love to know about that. We enforce, the city enforced the first salary history ban in the country, and AG Letitia James was one of the lead, most vocal supporters of that bill, and actually put out a study that I think launched kind of the momentum behind that bill. So her office could also look at this, and I think she probably has a lot of interest, continued interest in this issue. There is a Labor Bureau and a Civil Rights Bureau. I think it would fall under the Civil Rights Bureau of her office. They can enforce any law in New York State, including the local laws in the city. So they could be a good resource, and you can also bring that information to our office.
Thank you. This question, I guess, is more for me as a legislator. What about developing strategies to address age discrimination in hiring? Perhaps tax incentives for employers that hire these returners to the workplace, not unlike programs created for veterans. There are a whole bunch of different programs like this in state law. There's for veterans, for youth, for populations below certain income. I will certainly explore the question of whether there's even anything equivalent to this. We have a program for displaced homemakers returning to the workforce. I will tell you that the experience I know of is that even when there are tax incentives in place for prioritizing certain hiring, very few employers use them. Because most employers make the decision, I'm going to look to hire the people I need for the work I need done. We certainly hope none of them are discriminating based on your race or your sex or your age, or whether or not you were a veteran, or whether or not you come from a high poverty or low poverty area. But again, most of the research shows these bills or laws end up sounding good, but not translating into much of a change in hiring patterns. I don't know if either our guests have any experience with that, because I think it's more a legislative question.
I think you're the expert.
Okay. All right, discrimination on the job. So now let's talk about once you've gotten hired. How can I tell if I'm being discriminated against in the workplace because of my age?
I'll start, but Bianca, please jump in. So the way that the laws most, I think, reliably look at this is by comparators, which is imperfect because you're not always going to have a comparator. But if you look at sort of how projects are allocated, how promotional opportunities are decided, the makeup of the team, how you're treated, if you can identify that people under the age of X are treated differently or given certain opportunities, assumptions are made about their skill or about their, about their opinions, and older workers are not. And even if you can just kind of come up with one person to kind of compare yourself to, that's always probably, I think, going to be the strongest demonstration of what we call disparate treatment. You're being treated less well, you're being treated differently. Of course, there's harassment, which does not require a comparator. That is just simply offensive, demeaning, degrading treatment, and that is a very, very broad and generous standard under the city law. It's the same standard that applies in sexual harassment cases, which is not the federal standard of severe or pervasive. So even 1 or 2 comments that are demeaning about one's age or assumptions being made about one's ability because of their age would demonstrate discriminatory motive and create an environment that violates the city human rights law. Bianca, I don't know if you want to add anything to that.
Yeah, just in terms of comments, because I feel like there could be behavior that, sorry, there's a motorcycle outside, behavior that is not perceived as harassment, but I feel like age is one of those things where we're so used to hearing certain kinds of comments related to age that we don't even realize that it's harmful or discriminatory in some way. So I think just being conscious of phrases that seem so common, and just because they're common doesn't mean that they're okay.
True. So what do you do when you think that perhaps you're being discriminated against for age because of an assumption that you're not a digital native, as you used, I think, earlier on, and that there are assumptions about your cyber skills because you're an older worker, so that you're not being offered some of the types of work that younger workers are being offered, or in this situation where we are today, where people, we hope, can work from home if they are able. They're assuming you won't be a constructive worker from home because you can't possibly have the same cyber skills that younger workers do. What do you do in those situations?
I think it depends on what the individual would really want to do, but certainly that is one of the key areas that I think is most clear, potentially violation of the city human rights law. Assumptions about ability, assumptions about flexibility, about learning new skills, about having the relevant skills for technology, for social media, for whatever it might be. All of that, again, is assumption. If someone doesn't have a skill that they need to perform a job, that's a different conversation, and there could be conversations about training or about professional development. But if someone is making assumptions about either one's ability to learn the technology or to know the technology already, again, that's very much tied to age, and I think around this narrative around sort of the generational divide on some of these things. And we're trying, part of the purpose of the guidance is to try to challenge all of those assumptions and highlight that is actually potentially discriminatory if you're making assumptions about people's skills and ability to learn new skills or to even have them in the first place.
Right, and I'll just add that in the COVID-19 supplement too, we do mention, employers' concerns about moving remotely and then having to use more technology. And I'd say that employers should ensure that everyone, regardless of their age, is properly trained to work remotely, right, and is able to do that. It's the employer's responsibility to make sure just across the board that people are aware. And I know, speaking from experience, our agency has gone through tons of things that we've all had to learn, regardless of, whether we're 25 or 55. So, yeah.
So how would either of you advise people respond to being told, hopefully not actually told, but getting the sense during an interview or on the job that seniors who stay in the workforce are preventing younger people from being able to get those jobs, and that younger people need those jobs more?
I mean, to me, this reads of, women shouldn't be working because they have a man also working, in the home, which is some of the things that I know generations prior to mine encountered in the workplace. So I think, this idea of pitting one generation against the other is not new. We see it with race, we see it with gender, we see it with religion and LGBTQ rights. I mean, this to me is just, again, part of the goal. That is not something we fix with law. That is a conversation that we have to have as a society. And part of our motivation behind this was that these are, I think, really just entrenched kind of like blame conversations that are happening, we're all in a really tough spot right now. And I think seeing how it's hitting different generations and different segments of the population demonstrates that not one group is to blame. No one's holding on to wealth or jobs at the detriment to others. Like this should not be a zero-sum game. And I know that, AARP has put out so much information and studies around the benefits of a multi-generational workforce and how it improves everyone's experience. And that really is kind of what we'd like to focus on too. So I don't have an easy answer for that other than to say that this is not new and that perhaps this is like the newest challenge for us to kind of all think through. And I know, many of us are guilty of kind of thinking like, I can't relate to this generation or I can't relate to that generation. But, at least right now we should be coming together and looking out for our neighbors and our friends and our multi-generational communities. And not thinking about, who's pushing out who or who deserves what.
Exactly. Well, the last question is actually, what about age discrimination in running for political office? And I guess that one's for me. And I will say, first off, take a look at the two gentlemen who are the candidates from the Democratic and Republican parties for President of the United States. Clearly, we don't think you can be too old to run for office. I do think, personally, that the best model of government is when we have a mix of everybody who's a little bit like everybody in the real world. I think that government is stronger at the 100-year anniversary of the suffrage movement, when women not only vote, but women can be at the tables of power as elected officials. I proudly serve in the state Senate with an incredibly diverse conference from throughout the state who are Black, Latinx, Asian, white, Jewish, Christian, Muslim. I think we range from age, I have to be careful here, but I think the youngest is 27 or was 27 when she was elected a year and a half ago. And now I'm afraid to guess the oldest senator, but I'm going to say 80 at least. So I would encourage anyone who believes in democracy and our democratic process to consider the possibility of running for office. And I think that if you think about it at different ages, you will have different things to bring to the table. I didn't start in the New York State Senate until I was in my mid-40s. And when I got there, a few of the senators said, they're getting younger and younger. And I just started to laugh because I was like, I'm probably a middle-aged woman and you're treating me like I'm a kid who showed up. So you never know how people will interpret your role or your age from whatever perspective they have. I want to thank our two guests tonight. You brought terrific information to us. And please, everyone, get that booklet from the Human Rights Commission, because I think it is very valuable to have that and to keep track of this. And we want more people to know about these issues and to not be afraid to try to fight for their rights. Please understand, if you fight for your right in a job app, you're applying for a job and you think you're being discriminated against, it is important for you and others to take on that challenge, but you're probably not going to get the job at the place you complained about. Maybe yes, maybe no. People were talking about needing jobs right now. As we talked about in the very beginning, the unemployment rate has skyrocketed so quickly that everybody from all communities of all ages are suffering from not being able to get into the job market when they really need to. We have to work our hardest, look as hard as we can, and try to all survive this together. Again, I want to thank my tremendous guests, Dana and Bianca. We will be back in September with our next town hall, but we haven't scheduled the topic or the details yet. We'll also be trying a number of our other fall activities virtually. We're going to try a virtual senior resource fair because we don't think we can put 800 to 1,000 people in an indoor place at the same time, but that's not going to work. So we'll be experimenting with that. We'll be experimenting with our breakfast series for seniors in a virtual reality. We struggle every day to make sure we are responsive to you, and we are doing what we can in this new environment like everyone else. So stay well, stay safe, wear your face covering over your nose and your mouth to help keep yourself and others safe too. And just go ahead and wash your hands more times than you ever imagined doing so. It can't hurt. Thank you so much. Good night.
Thank you.
Bye.